Hey everyone, this is Rob Ryder on I think it's Monday, February 13th, 2012. Do a video, hopefully one of the last videos I ever have to do. This one's on special proceedings, and I want you to pay particular attention to what the definitions are and kind of what's going on as I read it. First of all, special proceeding is going to be used for most everything. Um, and it's certainly used for foreclosure. But it sounds like the petitioner, who is them, is trying to overturn uh, a decision that's already been made by an authority. I don't understand exactly what that means, but basically I think that you're in the civil courtroom when you're doing this, back in equity is some other paperwork that they're saying is yours or it could be theirs, and they're trying to claim superior title to it. And if we were just to claim the superior title, we would get whatever it is that's being contested that's sitting back in the court of the exchequer. Something like that. But let's just start with a couple definitions. Proceeding. It's a manner of interviewing in suits, of conducting them, mode of deciding them, of opposing judgments, and executing. So they're kind of opposing a judgment, right? That's one kind of a proceeding. They're ordinary and summary. Ordinary are by common law. Okay? Understood, regular, usual mode of carrying on a suit due to the course of common law. A summary proceeding are those when the matter is disputed without the intervention of a jury, which must be authorized by legislature, except perhaps in cases of contempt, for such proceedings are unknown to the common law. In common law, you get a jury, period. If you don't have a jury, you know you're in a civil case. It's not an ordinary proceeding. Okay, in Louisiana, they got a third kind known as an executory, talking about when a creditor's rights arise from an act importing a confession of judgment which contains a privilege or a mortgage in his favor. When the creditor demands execution of a judgment which is rendered by a tribunal different from that within whose jurisdiction execution is sought. Right? Yeah, think about that one. But in New York, so anyways, when they say Louisiana, we ought to remember they're talking about civil law in this thing. Louisiana civil law. New York, the Code of Practice divides remedies into actions and special proceedings. An action is a regular judicial proceeding. Common law, that's what it said up here, right? A manner of intervening in suits. An ordinary proceeding, in which one party prosecutes the other for the enforcement or protection of a right. So we're talking about rights here. Okay? Da-da-da-da-da-da. Every other remedy is a special proceeding. That's the definition. So in New York, as it turns out, I found how to commence a special proceeding. It's a government form. I'll put a link to it. I took it from a PDF, put it in Word, because you know how I like to highlight stuff and break it up. I had to do that to do this, but it comes as a PDF. Okay? Tells you how to do a special proceeding and what it's for. Special proceedings can only be used where it's significantly, specially authorized by statute. There are a number of these, but generally they relate to challenging the actions or determination of a government officer or agency. So you look at Article 78, and landlord-tenant relations can also be determined as special proceedings. In order to commence the kind of lawsuit known as a special proceeding, a person must prepare a document called a petition, which is a statement of the person's charges or the grievance of which the person complains. The person bringing the case is called the petition. Now, they have a hyphen in front of petition. I don't know what that stands for, but it follows through here. It's there on purpose. I don't know what the hyphen petition means, but it means something. So what's a petition? An instrument of writing or printing containing a prayer for the person presenting it, called the petitioner, to the body of the person to whom it's presented for the redress of some wrong or grant of some favor, which it later has a right to give. Petitions are frequently presented to the courts in order to bring some matters before them. It's a general rule, so this is a general rule in such cases, that an affidavit should be made that the facts therein contained are true. All right, so it's a general rule that they have to have that. Is there an affidavit? I was talking to Gene Keating. He says you never find them. All right? You can do a plea of the crown, brother, sister. So this is how you prepare them. Okay, you know, it's a certain size. The top left corner, you got a thing called a caption, which I really couldn't follow the definition. I spent too much time. And they got a thing called a respondent. The party sued called the respondent. The respondent or respondent's name should be the person's claimed to have made determination or decision at issue. So somehow we've made some kind of determination already, and they're trying to overturn it. And I think all they're doing is they're claiming they have superior title to the property, but they haven't put in an affidavit. So when we tell them they haven't put in an affidavit and we take it into court, they're going to go away. So again, we're looking for things that we can use on anything to get it into the King's Bench by doing a plea of the crown. All right, so you fill it in, got to do some stuff. So in English law, an inferior court, in obedience to the writ of certoria, returns an indictment to KB as annexed union of one thing to another to the caption. Then called the schedule. The caption concluded with a statement stating that it is presented in a manner and form as appearing in certain indictment thereto annexed. Caption is another name for an arrest. So, you know, they put things in a caption. I was trying to figure out, next comes the caption. What definition were they using? I'm still not sure. Anyways, the petition should set forth the allegations. So this is the way that they are supposed to do their paperwork. Right? I don't know how many things you need to find before you decide, okay, they've done fraud and you're going to ask for a plea of the crown, but we'll see if there's any other ones. The petition said set forth the allegations in the case in separate numbered paragraphs. Each paragraph should be short, contain only one material allegation. The petition should begin with a brief identification of the petitioner and the respondents. That's simple enough. Next, it should set forth a factual description of the determination of events upon which the claim is based in a chronological order, including the dates of key events. Look, if they get a date wrong, that's a reason for it to be unlawful. They may have done it on purpose. An omission on a date, anything, is a reason to appeal it to the King's Bench, to a court of law. Any incorrect date is reason enough for it to be considered unlawful, i.e. plea of the crown, which you are the plaintiff. And according to Blackstone, the king is a plaintiff with the plea of the crown. Our answer to their petition is a petition done as the king, asking, by what right does this special proceeding petitioner bring his claim? Make him prove it. The petitioner should be certain to set out factual assertions in a clear and coherent fashion. Bouvier's definition of a certain. So I put this in. Bouvier's definition of a certain. The third degree of certainty is that which precludes all arguments, inference, presumptions against the party pleading, and that is technical accuracy that is not liable to most subtle and scrupulous objections, so that it is not merely a rule of construction, but of addition. For where this certainty is necessary, the party must not only state the facts of his case in a most precise way, but add to them such as to show they are not to be controverted, which means disputed, and, as if it were, anticipate the case of his adversary. They have to petition in the most precise way what the facts are. Any deviation from precise is unlawful. Although the petitioner is familiar with the facts, he should keep in mind that the court will not be aware of them except insofar as they are presented to the court in the petition. Accuracy is important, and errors may be damaging to the petitioner's cause. Accuracy is important, and errors may be damaging to the petitioner's cause. Legible copies of any pertinent documents evidence should be included as exhibits, with index of tabs annexed to each such exhibit. If a proceeding concerns a claim that a government agency acted incorrectly or illegibly, a photocopy of the agency's final determination, which is the subject of the proceeding and intermediate ruling, must be included. So, what is the final determination that you made? Ask them what it is. Generally speaking, a petitioner may only obtain relief in this court in the form of review, and if successful, reversal of a final agency action. Right? They're trying to reverse something that's already been given to you, and I think it's just unclaimed property. Right? I don't know what it is, what piece of paper it is that they're after, but it's in the Court of Exchequer. It has to be. It's equity. They're after the res of some kind. And because there's more than one court, now you're in a civil court. I don't care what it said on the door. It's a special proceeding. Anything other than common law is a special proceeding. If it doesn't follow the common law, it's a special proceeding. You need to go to the Court of Exchequer. Got to find it. It's supposed to follow the king, so it's not going to be far from the king's bench, which is probate. The treasurer is in the Court of Exchequer. He most certainly is. Go accept his oath and ask him a damn question. Ask him what this means. Where's the final determination? Or go ask a sergeant at law, who anybody who sits on the king's bench has to be a sergeant at law. That it's a fraternity. That's not something they leave. It just happens to be a judge. But his fraternity is a sergeant at law. Okay, so in the case of a parking ticket, the petitioner is likely to be unsuccessful in the court if he did not fail to make the appeal entirely through. So, have they gone through the entire appeal process? Now, we're talking about a parking ticket. Okay, they're bringing a foreclosure. Have they gone through the entire appeal process? I don't know. The petitioner should clearly describe each step in the administrative process that the petitioner took, each decision made by the agency along the way. So, they're saying should clearly describe each step in the administrative process that the petitioner took and each decision made by the agency along the way and what the final action of the agency was. So what did they do and what did you do? It needs to be listed. There are time limitations varying the lengths of which lawsuits must be brought. In the case of Article 78, whatever that is, limitation generally is 4 months from the final agency action. What is the final agency action? The petitioner must make clear when the final agency action took place. Well, guess what? They need to tell you. And within 4 months, if this is Article 78, and I'm going to assume that this has to do with foreclosures, although I didn't check, right? This is New York, whatever in Article 78 a special proceeding is what they're talking about here. All right, so the petitioner should conclude with a demand for the form of relief. Frequently, the petitioner will seek reversible of the agency's action. Again, what did we do that they're trying to reverse? Setting aside and vacating the parking ticket, whatever that means. In such a proceeding, the petition should therefore state in so many words, or in effect, the petitioner prays that the decision of whatever the agency is, dated whenever, providing whatever it provided, be set aside and annulled. They have to tell you what it is they're trying to keep you from having. It's got to be in their petition. So who's the agency? In a special proceeding challenging the decision of a government agency, in regard to some claimed right of the petitioner, the petition should specifically state in detail why the petitioner contends that the agency action was wrong and must be annulled. They have to tell you why it's wrong. The court may overturn agency action only if the determination the action is made and taken. There's 3 ways to overturn what's already been given to you. Was a contravention of the law, similar to a misdemeanor in common law countries. So you broke the law. Well, if you broke the law, if it's a misdemeanor, right, you should be in a court of law and you should have a jury. Was arbitrary and capricious or an abuse of discretion? All right, well, they need to tell you that. They have to tell you what's wrong. or when a hearing is held at the agency level, was not supported by substantive evidence in the record. So you don't have enough evidence in the record for some reason when the hearing was held at the agency level. So some kind of hearing has already been heard at the agency level, government agency level, agency, the final, what are some other words? The final agency action. Everything's about this agency. What agency, brother and sister? Which one we talking about? The petitioner should attach to the petition a verification, that's an affidavit, which is a sworn statement by the petitioner under penalty of perjury that the facts contained in the petition are true. This document must be signed by the petitioner in front of a notary public who must acknowledge. We need to have an acknowledgement certificate, right? Actually, they need to go take an oath in front of a frickin' public notary, stamp and sign the verification. An example of verification. So did you find this affidavit? Now there was a reason I wanted to go back here. Yeah, maybe not yet. I forgot why I had that stuff on there. So in addition to the above, the petitioner should also be sure that he or she brings special proceeding in the proper county. There are a number of rules of what the proper venue for the case, generally relating to residents of the various parties. The underlying is the subject matter lawsuit. You know, again, all this you can get answered by a sergeant at law. I don't care if they're called that still or not. They cannot be a trial lawyer in a court of record unless they're a sergeant at law. And out of those are the ones that the judges are picked from. So whatever they're calling them today, I mean, people say, well, we see these acts where they're no longer in. It's just bullshit, man. Sergeant at law has been around since the beginning of the legal profession. And the laws of England have been in place longer than Rome has existed. It was ancient when Rome was nothing but a frickin' pup tent. You can believe this crap about civil law all you want. Or you can just go read an old book about the law and go ask some questions. Okay, so Article 5 of the Civil Practice Law. Now, generally, the petitioner must commence a special proceeding against a public body, I think they're saying your body, or an officer in any county within the judicial district which the respondent made the determination complained about. So again, you've made some determination, and that's what they're complaining about. Or refused to perform a duty alleged, but it has to be in the petition, what it is, or where the underlying proceeding were brought, or where the material events took place, principal officer, A lot of things they have to do. I bet you they're not doing any of them. Except to get you, through trickery, through concealment, to acknowledge something that's going on in an equity court in the back room. Okay, so how to set the wheels in motion, right? So again, I'm not going to read all this to you, but my main point in any of those is how they're doing these things. Now, there's another type of special proceeding, and they're going to put on an order to show cause, right? I don't think that this is necessarily for a foreclosure. This is more to do because there's two kinds of original writs. One is a we command, and one is we summons. It's an order to show cause. I believe that that's where this fits in. So I don't want to go too deep into that. My main thing is all these other things have to have been done. There has to be, right? No matter where they start in this, New York requires a paper commencing a special proceeding must be filed in the county clerk, and that an identifying number, index number, be obtained. The petitioner should go to the county clerk's office. The petitioner will have to fill out an index number cover sheet. Petitioner must write the index number assigned to the county clerk, right side of the caption. So first of all, they need to go to the county clerk and get an index number. Okay, does your special proceeding have an index number on it? A copy of all these documents must be filed with the county clerk. We'll open a court case in the file. The clerk will stamp the petitioner's copies to show the papers were filed and issue a receipt to the purchaser and the index number. The petitioner needs to file with the clerk the following initial legal papers: a copy of the petition and a notice of petition, or a copy of a petition and a copy of order to show cause. Now, this isn't in the court. This is the county clerk under this index number. In some jurisdiction, such as New York, order to show cause is used routinely to initiate a motion when a traditional notice of motion would not be sufficient. For example, when a moving party wishes to vary the usual schedule for considering a motion, or when a temporary restraining order or other provisional remedy is sought. I have to go look up provisional remedy, see what that is. In order to bring the proceeding before a justice, the proper title of a judge assigned to a Supreme Court is justice of this court, the petitioner needs to request the case be placed before the justice on the calendar. This is done either one of two ways: by serving and filing a notice of, there's a hyphen petition again. I don't know why that is. So a notice of petition. A notice of petition is a document directed at the respondent that advises the respondent of where and when the petition is to be submitted to the justice and identifies all papers upon which the proceeding is to be based. All right, so a notice of petition, it's going to be to you, advises the respondent of where and when the petition is to be submitted, when's it going to be submitted to the justice, and identifies all papers on which the proceeding is to be based. So that's telling you this is all their evidence they're putting in. In order to show cause also serves to give notice to all parties, but in the form of the document is different. Annexed, they got one someplace. Special proceeding, this document, unlike the notice of petition, is in reality a court order. So an order to show cause is a court order. It must be presented to and signed by the justice of the court at the outset of the proceedings in the court. So it's got to be signed at the outset, right at the very beginning of the process. Please note, the court is under no obligation to sign the order to show cause or grant temporary relief. It may instead tell you to make your application by means of a notice of petition. So did they sign the order? Right? Well, you're going to know, because these are all things that need to be in the file. You have to have all these done in order to bring a proceeding before a justice. Petitioner needs, before the calendar, one of two ways: file a notice of petition, or an order to show cause. And if they do an order to show cause, it has to be signed by the justice at the outset of the process in the court. When moving by order to show cause, a petitioner should prepare a petition as explained above, and also order to show cause in the form similar with the example in the annex. The petitioner should bring original 2 copies of the papers to the court. 1 copy should be filed with the county clerk, as explained above. All right, so all this needs to be filed with the county clerk and get a index number on it. Right? So all this shit you should find. You better find that this judge has already signed the court order. Now, again, I don't think that this is for a foreclosure, as much as like Jason's brother who had an indictment against him, right? That's what they're talking about here, more like indictments. And here's the things to go look for. And you go to the county clerk to see if it's been filed there first. Bring the originals. The petitioner should also complete, I got another form they got to fill out. I don't know anything about it. Make clear the court the kind of case involved. So it's pretty important. The purpose of this form is to make clear to the court the kind of case involved and to formally request intervention of the justice. So they need to tell you on here what kind of case it is. And so it's a request for judicial intervention. I'm sure every state has their rules for special proceedings, right? But they're all going to be about the same. At this point, a filing in the county clerk has been, so all these things have happened. At this point, a filing in the county clerk has been made, but a filing with the court is not yet occurred. The petitioner should next proceed to the Supreme and County Court Clerk's office. The original petition, in order to show cause, which already has to be signed, must then be presented to the clerk in that office, together with proof of the previous filing with the county clerk, proof of purchase, the index number, number of the completed form, the index number on that completed form, together with the certified check. So they got to pay with a certified check or a money order. They can't pay with their own check. It has to be a certified check or a money order. Their checkbook's no better than yours. So look to see how they paid for it. But this, right now, see, this is where it's now going to the clerk, right? So there's a record here in the court that they're going to use in the court. And then there's another record that's already done that's sitting back in the county clerk's office. It's just going to sit there. And I think if you get a copy of both of those records and you compare them to each other, and you would find them by the index number, you're going to see that there's erasers, omissions, scratch outs, whatever. All these things are reasons for it to be appealed to the King's Bench. Everything. Any of those things will make it unlawful. A strikeout, whatever. So the clerk's office will then review the petitioner's papers, make sure they're in proper form. Just going to check the form, and if so, assign a case to the justice. Yeah, if you need an emergency, then they'll submit some. Then they got to do an emergency affidavit. You want to get it done quick, you got to put in an emergency affidavit. Again, an affidavit means they're swearing to whatever the allegation is. The papers will then be delivered to the assigned justice for immediate review, and if found acceptable, signed by him and given to you, you, the one doing the petitioner, so you can copy them and return the originals to the county clerk's office. So again, you go through all this. If this is what he does, he needs to go return the originals to the county clerk's office and arrange for them to be served in a manner directed by the court. Well, how did the court say to do it? Is that how they were served on you? They're not hiding anything. Just read the damn paperwork. And if not, then the papers are simply left with the county clerk's office. The papers are reviewed, marked for return, sent to assigned justice for signature, yada, yada, yada. How many more pages we got here? If your papers are correct as to form, not necessarily substance, but as to form, they will be forwarded to the county clerk's office, assigned to the justice chambers for signature. Justice finds them satisfactory, he will sign them. Fill in the date and fill in the return date and specify when and how the papers are to be served. So we want to look at this return date that they talk about and see if that's the date that they returned it to the court. I need to go do a little more research on return dates, but it has something to do with the date it's supposed to come back. If it isn't on that date, guess what? It's unlawful. When the order, the show cause, has been signed, the petitioner must conform a copy, that is, reproduce a copy of the papers with each and every marking made therefore by the justice. This copy then must be photocopied and served upon the attorneys for all parties to the case in the manner and within the deadline set by the justice by the return date. You better have a copy that has every frickin' mark on it that the judge has. For information about the service, ask public. Okay, that's about having it served on you. So how to serve legal papers. Did they do it the way it says? Maxwell says exactly how they must serve to show cause to be lawful. And that would be Book 3, chapters like 18 and 19, in that area. They're all good. But that's where he's going through all the different steps of a court case. After service is made, petitioner must see that an affidavit of service is prepared. The original must be presented to the court on the return date. So, after service is made, when they've served it on you, an affidavit of service has to be done, and the original must be presented to the court on the return day. The petitioner must be present at the time. The petitioner must be present at the time, especially if the court granted a stay. Petitioners must ask for this when the order to show cause is called before the court at calendar call. If the other parties do not submit opposing papers and do not appear on a return date, the court may take action on the order to show cause, provided that it's satisfactory from the affidavit of service. So you can either put in papers or you can show up on the return date. So what papers are you going to put in? I'll put a plea of the crown in. And say, apparently there's no original writ. You know, sued out from the Court of Chancery under the Great Seal. Therefore, this civil case is only worth no more than 40 shillings. Why am I here? And I'm going to go ask a sergeant at law, which I think you'll find in probate after 11 o'clock in the morning, because the King's Bench sits from 8 in the morning till 11 in the morning, and then the rest of the day in that court is used for people to come see sergeants at law to talk about their case. Okay, moving notice by petition, yada yada yada. The proceeding can be brought before court without need for a justice. Oh, so if you don't want to have the justice sign the order, then you petitioner may proceed directly by notice of petition. So he should prepare a notice of petition and the RJI. Petitioner must select a return date, identify the place and the matter is to be heard. So this is what the petitioner does. He chooses a return day and identify the place in which the matter is to be heard. The place is the courtroom in the assigned justice. The return date is any weekday at 9:30 a.m. He has to bring it in at 9:30 a.m. But the return date must be selected, keeping in mind the respondents must be given adequate time to prepare. And then, okay, so at least 8 days after serving. If it's Article 78, you get 20 days. And then it gets randomly assigned. Original papers must be delivered to the clerk's office at least 5 business days prior to return date, so the petitioner may be recorded in the court's computer system and placed on the calendar. In the first instance, the place at which the motion will be returnable is assigned justice courtroom. Oral spoken argument may take place there, but usually oral arguments take place only when and where and if the assigned justice directs. This is so for all petitions brought in our court by notice of petition. The parties are free upon agreement to adjourn petitions within limits so as to accommodate their schedule. Answering and reply papers are to be served upon all other parties in the case. Deadlines applicable. Original answer and reply papers, which must be attached to proof that the papers were served on all other parties, must be delivered to the courtroom on the call, at the call of the calendar at 9:30 a.m. on the return date. They don't bring it in that date, then their paperwork isn't any good. And the petitioner needs to bring it on that return date. A word of caution on return date. Sometimes an assigned justice or court clerk's office will direct or require a change in the return date you've selected. Accordingly, a few days after you submit your notice of petition, you must check with the clerk's office to see if that's happened. All right? You can do this by calling the court. Well, how many times do you think they do this? They're as dumb as we are. Once the motion is marked and submitted, it's either sent to the justice assigned for the case, decision, or scheduled for oral argument in front of the justice. This depends on the procedures adopted in the justice in question. Remember, you're responsible for keeping track of the status of your petition after it's submitted and doing whatever follow-up is necessary after it's decided. I'm sure they're not doing this stuff, right? Well, first of all, you're not going to find a frickin' any affidavits in here. Okay, well, that's what I had to say. And then just real quick on this, just some things that I pulled out that this is out of Blackstone's Commentaries, Book 3, Chapter 4. For in order to be entitled to sue an action of trespass for goods before the king's justices, justicars, the plaintiff is directed to make bona fide make an affidavit, the cause of action does really in bona fide good faith amount to 40 shillings, which affidavit is now unaccountably disused, except in the Court of Exchequer. You better have it. The Court of the King's Bench retaining all jurisdiction which was not cantoned out to the other courts, and particularly the superintendents of all the rest by way of appeal. Everything can be repealed to the King's Bench, appealed. And sole cognizance of pleas of the Crown or criminal causes. So a plea of the Crown is for mortals. This is just mortal. Or criminal causes. A plea of the Crown is merely a complaint where the plaintiff is the king. And so you write plaintiff and put your name, and because it's called a plea of the Crown, it's from the king. For pleas of suits are regularly divided in two sorts. Pleas of the Crown, which comprehend all crimes and misdemeanors wherein the king, on behalf of the public, is the plaintiff. It said the king, didn't say anybody else, it said the king. This certain place was established, Westminster Hall, the place where the Allura Regis originally sat when the king resided in the city. And there it has ever since continued. The court being thus rendered fixed and stationary, the judges became two, and chief with other justices of the common pleas were thereupon appointed, with jurisdiction to hear and determine all pleas of land. So the common pleas is the land court. So I was talking to Carl today, and he didn't get some answers that he was hoping to get from the Register of Deeds. And now, Carl, go back and ask them if they're the land court. They have jurisdiction to hear and determine. So more on proceedings. The word proceeding may be used for all actions, or it may be used for something other than the usual type of lawsuit. Special proceedings may be commenced by a petitioner motion even when no full-fledged lawsuit is pending. They usually are confined to disputes that are not recognized under common law and equity. That's what special proceedings are. That's what they call what you go into for foreclosure. You got summary proceedings, and you got supplementary. And you can stop to read it if you want. I'm moving on. So one of the counties, special proceeding court. So, I went in, I don't know, I just did a Google on special proceeding and found that the special proceedings division is located behind the elevator's 12th floor, Wake County Courthouse. Their primary function is as follows: adoptions, foreclosures, name changes, guardian proceedings, incompetency hearings, claim and delivery hearings, exemption hearings, motor vehicle liens, judicial waivers. Well, there's foreclosures and guardianship proceedings. It sounds like a lot of things to do with probate. Special proceedings in Soviet civil procedure. All civil procedures are the same. A type of procedure in a court of original jurisdiction. Special procedures are used in hearing cases which, unlike suits, in cases arising from administrative law relationships, there is no dispute as to legal right. So in a special proceeding, right now there's no dispute as to the legal right. Well, let's dispute it. Examples include cases to establish facts that are legally important, such as, to declare a citizen missing, to dead, declared a citizen of limited capacity, incapable to declare properly ownerless, to declare it abandoned. They're trying to declare something abandoned so they can take it from you, but all you need to do is claim it. It's already yours. This authority from the other papers already said it is. Special proceedings are also used in cases involving complaints against actions of notaries and agencies performing notary functions in the case of restore rights under lost bearer documents. The court hears cases of special proceedings on application of interested persons and organizations. If a dispute as to the legal right arises while the case is being heard by the procedure special proceedings, the court leaves the application unheard, and the interested parties may initiate a suit in a court according to general rules. And in the general rules, they have to put these affidavits in. So all we need to do is have a dispute of legal right. By what right do they do this? That's all we need to know. Yep, and this was just kind of a carrying on with that other stuff from the other one. Okay. Really, that's it, guys. Everything is a special proceeding. All you need to do to get it out of a special proceeding is to dispute of a legal right. They're supposed to lay out plainly in the petition what it is they're after, what this government agency has already determined. If they haven't done that stuff, they don't have a case. So all sorts of things that you could take to a sergeant at law. Or you could write into a plea of the Crown and just submit a plea of the Crown into the case and demand that it be appealed to the King's Bench. Because there's no affidavit under penalty of perjury in the case. And you don't believe they have the legal right. You demand they put in an affidavit. If they refuse to, they lose. It's really that simple. Okay. Call it a tape for now, and like I said, I hope this one the last ones I have to do. I'll talk to y'all later. See ya.